With respect to the first prong, Your Honor, the state has successfully assumed a position. The state took a position in a motion that witnesses should be excluded, and the defense, after full briefing of the case and in reliance on that position, the defense then conceded the state's the relief that the state had sought as to 5 of the 9 witnesses that the state was looking to have excluded. So the state was successful. In its motion, the state tries to indicate that that in fact a party must have already had the matter adjudicated by the court in order for there to be a successful position that was taken by the court. And I'm going to go to the state's motion. And so what the state says is that this must have already been adjudicated by the court in some way through some order by the court. There have been no arguments, is what the state says. The state says the record in this case is crystal clear. There were never any hearings or other judicial proceedings in which the state's initial motion to exclude certain defenses was adjudicated by the court. And therefore, their position is that that means that there was no, that we don't meet the first prong. However, that's incorrect, Your Honor. And if the court will look at the case that we cited, and it's Kuchan, which is a 2024 case, the site is 2024 NMCA 032. And when we look at this case in paragraph 14, the court notes that the respondent in that case did not successfully argue and therefore assume this position in a motion or at hearing. So the use of the word "or" clearly demonstrates that a party can assume a position either by its argument through a motion or also by its argument at a hearing. So it's either or. It doesn't have to be at a hearing. It can also take a position through argument in a motion. And this is further solidified through paragraph 16 of the same case. In paragraph 16, the court continues and states that the respondent could not be considered to have successfully assumed a position about the nature of the West Track until filing the motion for partial summary judgment. It doesn't say until argument of the motion. It says that upon filing of the motion for partial summary judgment, that is the moment at which the respondent could be considered to have successfully assumed a position. And that is what the state did in this case. They assumed a position in the motion that they filed, both the primary motion and then also their responsive briefing. They assumed a motion, or I'm sorry, they assumed a position. And they successfully assumed that position because the relief that they sought was granted effectively by the defense consent to that relief. The second prong, Your Honor, has, and I will actually point out the cases that the state cited for this principle. So that was the one that the defense cited. The state cited 3 cases in support of their proposal that that a motion has to be argued before the court and there has to be an order in order for there to be a successful assumption of a position. They cite O'Brien, they cite the Gabriel Vigil case, and then they cite a 2014 unpublished opinion, which is non-precedential. So I'll go over the 2 cases that are actually published case law. For O'Brien, in this case, this is a case where the court did apply judicial estoppel. And there did happen to be an order that was entered by the court. It was a pretrial order, but merely finding a case where estoppel was applied and where the court had entered an order does not indicate that the first prong can only be met where the court has entered an order, and that is not the holding of the case. It just so happened to be that in that case, there was an order that had been entered by the court, and therefore that met that part of the prong in the either or. So either in a motion or at a hearing. And so in this case, there was a hearing that was appropriate, but that does not say anything about the fact that one can also take a position through a motion. The Gabriel Vigil case, this one doesn't even deal with judicial estoppel. It actually involved the doctrine of collateral estoppel, which is a different doctrine. So collateral estoppel has a different test than judicial estoppel. And the purpose of collateral estoppel is to promote judicial efficiency and consistency, and the goal is basically to keep parties from relitigating issues from a previous suit. With judicial estoppel, we're talking about a purpose that has to do with protecting the integrity of the judicial process by preventing the parties from, and this is quotes from the various cases, from playing fast and loose with the court and ensuring that the party does not manipulate the judicial system. So in light of the fact that there is a 2024 case, which is the case that the defense cited, that precisely states that a party can assume a position pursuant to the first prong through motion alone, the question again is whether or not they were successful, and we submit to the court that they were. Now moving on to the second prong. The second prong says that the first position is necessarily inconsistent with the position that they take later. Clearly that is the case. Clearly that has been met. The state was first saying that there was prejudice by the inclusion of these additional witnesses on the defense witness list. The state's position was that those witnesses should be excluded, and now they have taken the exact opposite position, saying these witnesses should be able to be called by the state and there is no prejudice by their inclusion. Now, even though only the two prongs are actually required, the third prong again indicates that if the party's change of position prejudices the party who had acquiesced in the former position, then judicial estoppel will be especially applicable. And that is the case here. So the defense relied on the state's motion, which the state had told the court on May 31st in their notice of completion of briefing was fully briefed and was ready to be heard. And in recognition of that fact, and recognizing that we are scheduled for trial for 8 days, in an attempt to pare down our witness list substantially, we removed, again, almost half of the witnesses from our witness list, revealing significant defense strategy. And we also informed our witnesses. There were some witnesses who were scheduled to be interviewed the following day, and then a couple of days later. We informed those witnesses that they were released from their subpoenas, and we did, in fact, release them from the subpoenas, and we told them that those interviews would be canceled. We sent, again, courtesy copies of our notice to the state along with our amended witness list, and then that's when, within less than 3 hours after seeing defense strategy, the state changed its position. Now, the state proposes that really they can just cure any prejudice to the defense by extending deadlines. But that doesn't cure our prejudice for a variety of reasons. Primarily, because you cannot cure the fact that we have already revealed defense strategy in reliance on the state's position, and the state has now walked that back. We cannot cure that. In addition, we're in a time crunch at this point, Your Honor, and we do not have further time available. The state, in their motion on May 6th, noted that that they were prejudiced by the fact that there was only 8 weeks prior to trial. We are now in the position where we only have 2 prior to trial. We did not receive significant information from the state previously, and the reason that that is relevant here in particular is because time is a finite resource. The recordings alone that were disclosed related to Hannah Gutierrez-Reed are so significant and substantial that if we take an average of the time that it would take to listen to each of the calls, and we dedicated one whole person doing nothing else, taking no breaks for a full 8-hour day, it would take that person approximately 15 business days to listen to the recordings. But we don't have 15 business days, we have 10. And not only that, we also then have to look at the potential of having to interview Ms. Gutierrez-Reed. So time at this point, Your Honor, is a finite resource, and the state is playing games to exploit that resource and to take time away from the defense where we should be spending our time in trial preparation. Instead, we are having to deal with the state's constantly changing positions, with their changing disclosures, with the new things that they're adding, and it's fundamentally unfair. And as the state notes in the state's own words, calculated sandbagging is not appropriate. And what they say in their own motion is that they say this kind of manipulation of the courts should not be permitted, and we agree. And so we are asking the court to therefore exclude the witnesses and to grant the defense motion.
I have a couple of questions before I hear from the state. This first, you talked about that you had to that you decided that you were going to limit your witness list, cut it down because you had to switch gears for trial preparation. The time for investigation was superseded by preparation. If I'm misstating that, tell me right now.
No, Your Honor, that's correct. That is a big part of the consideration as well, which is why we were assessing our case in that moment to determine what needed to be done.
And so you said that you made this strategic decision, and that, but I'm not clear, and that they know what your strategic decision is. Is it anything more than you eliminated a witness?
No, Your Honor, we did not include any additional dialogue with the court or information in the pleadings, but again, we had pared down our witness list to almost half of what it was. And so I think that gives the state a pretty good idea of what we're going to be doing with the case.
Okay. And so then you're talking about this sort of bait and switch is what you're saying, where on May 6th, they had a problem with your witnesses, and then on June 2nd, you took certain ones off, and then on June 2nd, they added 3 of the witnesses that you took off. And I'm not quite sure how that short time frame I know you're arguing a little more than short time frame, but that's quite a short time frame, right?
A short time frame for what? I'm sorry, Your Honor, if the court would
for
clarify.
for them to have added the 3 witnesses that you deleted.
Correct. Yes, it was a quick turnaround. Right. That is correct. Within hours.
And how do you explain that they have always added at the end any witnesses called by the defense, and that you had these individuals on?
That's correct, Your Honor. And so it's a different position, I think, than we would be in if, let's say, the state had not filed a motion to exclude. That's the part that changes, I think, the analysis in this case, because at any point, of course, one party or another can remove witnesses from their witness list. We could not add any more witnesses based on the court's order, but we could remove witnesses from our lists. And there was the catch-all of, any witnesses who were listed by the defense or by the state, and that is correct. However, what's different about this particular situation than the typical instance in which a party may just decide to go ahead and remove witnesses is that we did so in advance of the final trial witness list, for example, that this court has, which I believe is Monday. And so we did so in advance of that in order to say, okay, we're not even going to finish doing these other witnesses. We know where our case is going to go. We're pulling these people off, and this is what we're going to do. And we did that in reliance on the briefing that was filed by the state. And so it's a bit of a different position because the state had already effectively indicated to the defense as well that they did not intend to call those witnesses by moving to exclude them. You can't move to exclude witnesses from trial for the defense, but then be keeping them for the state. That's not what they were saying in their motion. So what they were saying was these witnesses should not be called at trial. And so they're saying that they also will not call those witnesses. We then in reliance said, okay, fine, we agree to not call those witnesses. And so this is a different position than one party unilaterally just removing witnesses from their witness list because it was done in reliance on the state's briefing and on their motions.
So the prejudice is what?
So the prejudice,
you went into this whole thing that is not in your, it's more of your Brady violation motion. So what's the prejudice?
So the prejudice at this point, Your Honor, is we already had canceled and released witnesses from subpoenas. So they were no longer valid subpoenas since we had already informed the witnesses that they no longer had to be there. The witnesses, even though some of them had already been interviewed, the problem is, and again, we don't want to go through an analysis of what each of the witnesses would be because we're not going to reveal further strategy to the state than we already have. And so we're not going to do an analysis piece by piece, to tell them what the import is or is not of each of the witnesses. But suffice it to say that we did an analysis of these cases as a group, as a whole, could be released and could be removed from our witness list together. If only some of them are now coming back, then that can again impact whether or not there need to be other witnesses who would still remain on the list whom we have not interviewed. And the state says, we can just extend the deadline, right? We can extend the deadline to take care of that issue. That's the state's proposal. But again, we have a finite amount of time and we are in full trial prep mode at this point. And so that's the prejudice, Your Honor.
That you can't interview 3 more witnesses because you might have to interview some additional ones.
And that's the thing, is we made a decision and a call based on whether or not we might need additional witnesses. That's correct, beyond that. But at this point, we don't have the ability to do that. And so that's the prejudice.
So the prejudice is that you're preparing for trial and you can't do these pretrial interviews. I'm trying to, you need to articulate it for me.
Of course, absolutely, Your Honor. So that is certainly a part of the prejudice. And so it's multifaceted. So that is a part of the prejudice. The other part of the prejudice that is specifically related to the witnesses is in releasing or removing nearly half of our witness list. We also, again, some of these witnesses are interconnected. And so now we have removed 11 witnesses, and the state is now adding back piecemeal, which witnesses they want to put on. And it happens to be some of the ones that they had moved to exclude. Those are the ones who they've listed as being added. And so the prejudice is that it does impact our case and our presentation.
And then your judicial estoppel is talking about fast and loose, but you're also that, they took one position and then they took another position, but you're talking about all in the same, I don't know, what is it, 48-hour period? I mean, what they added them and then did their withdrawal, and you're talking about that constituting judicial estoppel?
Yes, Your Honor, because it wasn't just that one moment either. It was the fact that this had been briefed over the course of a month as well, and the state had indicated that the briefing was completed. And these witnesses, in particular, they were very difficult for us to serve as well. We don't know that we would be able to get them back. We had difficulty serving them through our process servers, and they were hard to find. And then there was also one who was released who was actually an out-of-state subpoena witness. And those also take additional time that we don't have at this point.
Appreciate it. Thank you.
Yes.
I don't know who's going to be arguing.
It's me, Your Honor.
Okay.
Thank you. May it please the court. Your Honor, the case that actually governs this court's analysis is State versus Harper. And in State versus Harper, the New Mexico Supreme Court at 211 New Mexico Supreme Court 44 paragraph 2 noted that exclusion of witnesses requires an intentional violation of a court order, prejudice to the opposing party, and consideration of less severe sanctions. And when considering sanctions, prejudice to the opposing party is a central consideration. And in Harper, at paragraph 19, the Supreme Court noted that even when a party has acted with a high degree of culpability, the severe sanctions of dismissal or exclusion of key witnesses are only proper when the opposing party has suffered tangible prejudice. And in this case, Your Honor, first, I would submit to the court that prosecutorial discretion allows the prosecution to make decisions with regard to the evidence it plans to present at trial. Unless bad faith is demonstrated, those decisions are generally not subject to review. I would submit to the court that in this case, what happened, Your Honor, is that on May 6th, there were a number of witnesses disclosed. Because that was the pretrial motions deadline, the state had no idea the defense was planning to call these witnesses. So we filed this motion. But then these witnesses were set for pretrial interviews, the ones that the defense now seeks to exclude. These witnesses were interviewed. These witnesses, then the state investigated the statements of these witnesses and determined over a period of that weekend that it would be there would be no prejudice to the state. So we went ahead and withdrew the motion. And so what's important for the court to know, Your Honor, is that Mr. Zach Sneesby, which is one of the witnesses that the defense fortuitously decided to withdraw, actually was interviewed the week before, the last week in May. And during his interview, he revealed that he was standing very close to Mr. Baldwin when he shot and killed Halyna Hutchins. And Mr. Sneesby specifically said he saw Mr. Baldwin pull the trigger. And as you know, the defense position has always been that he didn't pull the trigger. Well, now there's an eyewitness who actually says he saw him pull the trigger. And he said this during his pretrial interview. The state conducted additional investigation and determined that it would then withdraw its objection or opposition to these witnesses. There was no bait and switch. There was no bad faith. And what's important, Your Honor, is that these were defense witnesses. It's not like these were state witnesses that were not made available for pretrial interviews. These were defense witnesses. Presumably, the defense had spoken to them, had investigated what they were going to say, and they disclosed them on their witness list. So for them to now argue prejudice is, I would respectfully submit, disingenuous, because they are seeking to exclude and claiming prejudice because they withdrew and didn't have time to set up pretrial interviews of their own witnesses. Well, if we're going to list witnesses on our witness list, we first interview them, find out what they have to say, and then we list them on our witness list if we believe their information or the evidence they're going to present is relevant. On May 6th of this year, the state filed its witness list. The 45th witness, as the court noted, is any witness disclosed by defense, called as a witness by the defense, or listed on the defense witness list. The fact that the state then listed the witnesses the defense sought to withdraw on its witness list does not result in a violation of the rule, because we did, as the court pointed out, the 45th witness was any witness listed or disclosed by the defense. Your Honor, with regard to the prejudice, because before the court can impose the severe sanction of exclusion, the court has to find that there is prejudice. At paragraph 19 through 21 of the Harper decision, the court specifically stated, and I quote, "The requirement that any serious sanction against the state be conditioned on a finding of prejudice is well established in our case law. Prejudice must be more than speculative. Therefore, when discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defense preparation for trial." These were defense witnesses, and that bears repeating. These were not state witnesses that the state suddenly disclosed a few weeks before trial. These were their own witnesses that the state put on the witness list on June 2nd. Therefore, Your Honor, under Harper, I would submit to the court that there has been no intentional violation of the court's order. In fact, there has been no violation of the court's order, and therefore the extreme sanction of exclusion is not justified. The state offered and continues to offer. We will agree to extend the pretrial interview deadline. If they wish to interview yet again, potentially their own witnesses, we have no objection to that. We have no objection to extending the pretrial interview deadline. And that would be the appropriate remedy in this case, Your Honor. With regard to the doctrine of judicial estoppel, I would submit to the court, Your Honor, that this is a doctrine that would not be applicable in criminal cases. And we cited to a case that could be analogous for that proposition, and that's State versus Arevalo. And that's 2002 New Mexico Court of Appeals 62 decision, wherein the New Mexico Court of Appeals refused or rejected the application of non-mutual collateral estoppel. And in that case, the New Mexico Court of Appeals, in citing Standifer versus United States, a U.S. Supreme Court decision from 1980, noted that the question whether the contemporary doctrine of non-mutual collateral estoppel basically is an unknown for New Mexico courts. Now, in New Mexico, with regard to criminal cases, the important interest in enforcement of criminal law and the public interest in the accuracy of justice of criminal results are not present in civil litigation. So what the defense is asking this court to do is to apply a doctrine from civil law to a criminal case. And we have different concerns, Your Honor. We have different concerns in a criminal case as we do in a civil case. And so as the court in State versus Arevalo rejected and refused to apply the doctrine of non-mutual collateral estoppel, this court must reject the defense invitation to apply this judicial estoppel doctrine to this criminal case. The state was not able to find any case where the doctrine of judicial estoppel was applied in a criminal case. And that's because based on Arevalo, the appellate courts in this state would likely reject the application of that civil doctrine to a criminal case. But assume even if the court were to consider applying judicial estoppel, the state respectfully submits, Your Honor, that the defense has failed to meet the requirements. First, the party against whom the doctrine is to be used must have successfully assumed a position during the course of litigation. Now, the defense argues that there need not be a judicial decision. The state submits to the court that that is a prerequisite. And even the case that they cite to matter of state of Kuchan at paragraph 14, the court specifically says, quote, under New Mexico law, a party successfully assumes or argues a position when the party takes that position before a judicial body, that position is at issue and the party is ultimately successful. The Kuchan court cites to Wooten versus Vinson. And in that case, the court declined to apply judicial estoppel in a dispute over attorney's fees to the plaintiff's argument that the fees were reasonable, in part because the plaintiff did not ultimately convince the district court that her attorney's fees were unreasonable. This court had not yet ruled on the state's motion. So that prong of the judicial estoppel doctrine does not apply in this case. Counsel argues that, well, it's either a motion or they could have an order and the first prong is met. Given the language from the Kuchan case, the New Mexico courts, appellate courts would likely find and did find in that case that there has to be some judicial decision as it relates to the position that was taken by the party. But assuming the court finds the first prong is met, I would respectfully submit that the defense has failed to meet the prejudice prong. And the judicial estoppel doctrine requires the defense to establish that they have suffered prejudice. There has been no prejudice in this case. Again, these were defense witnesses who were disclosed by the defense, presumably interviewed by the defense, and that's why they disclosed them, because they obtained information that they believe would be favorable to their position. So there is no prejudice in this case, and we're talking a very short period of time. And again, prosecutors' pretrial decisions carry or enjoy a strong presumption of regularity. Unless there has been a showing of bad faith, those decisions should remain in place, Your Honor. There is no prejudice to the defense as it relates to this particular issue. And as I noted, Your Honor, under Harper, the decision here would be to extend the pretrial interview deadline, allow for the defense to speak to their own witnesses, and any prejudice is cured. And we would respectfully request that the court deny the defendant's motion to exclude these witnesses.
Reply, Ms. LeBlanc.
Yes, Your Honor. I'd like to address a couple of the cases that the state has raised. First, with respect to Arevalo, State v. Arevalo. On this case, Your Honor, where they're talking about mutual collateral estoppel. Again, collateral estoppel is a different principle, but what the court was deciding in this case was there were two co-defendants, and they each had been assigned separate jury trial settings. At one jury trial setting, one of the co-defendants was found not guilty. Then the co-defendant who was set to go to trial second, then instead filed a motion for judgment of acquittal, asserting that because the other co-defendant was now found not guilty, that the same should apply to him. And so that was what the decision was, and the court, found that there was a lack of mutuality. So this is, a very different analysis than judicial estoppel. There is precedent, however, for the use of civil type doctrines or principles when we look at, for example, specific performance that derives from contract law. And we have cited cases in our motion as well that have to do with the proposition that when the state has made an offer of a plea agreement where the defendant detrimentally relies on that offer, even if it has not been yet accepted by the court, then the state has to engage in specific performance and leave that offer open. So there is precedent, Your Honor, for the inclusion of civil doctrines within the criminal context when it is appropriate. And in this case, it is appropriate in order to maintain the integrity of the judicial process. The other proposition that the state has put forth before the court was that basically criminal prosecutions and their discretion in initiating and conducting those prosecutions will not be disturbed, those decisions by the prosecutors. And for that proposition, they cited Blackledge v. Perry. And in this case that was cited by the state, actually the court did not say that the prosecutorial discretion would stand absent bad faith. They say the opposite. What they said was that even in the absence of bad faith, the state cannot indict on a felony after the defendant had been convicted on a misdemeanor and then appealed the conviction and got a trial de novo. And they said even where there was not bad faith, the prosecution cannot do this because, in fact, they don't want this to have a chilling effect on defendants who would be exercising their right to appeal. And so that is not accurate, that bad faith is the only way in which a prosecutorial discretion can be overturned. And I would ask the court to consider the fact, again, in the state's own words, in their motion that they filed on May 6th, the rules do not contemplate gamesmanship, and this court should not countenance such conduct. I will also point out as a couple of final points that the state talks about, the time the defense had to investigate this case. However, the state has had even longer. The state has had nearly 3 years to investigate this case. And somehow within that short window of, less than 48 hours between when the last witness had been interviewed on May 31st, and then the moment that the defense had submitted its courtesy copies and filed its notices of withdrawal of witness and also its new amended witness list. Within that period of time, what changed? What additional investigation was had that didn't already take place before? They have told the court nothing about any of those specifics. What changed was that the defense revealed its position, and then they sought to take advantage. And in addition, the state says that they filed its motion to exclude as a placeholder motion. First, in order to file a motion, there has to be good faith. You have to have an actual basis to file a motion. The state in their motion claimed prejudice. That is different than a placeholder motion. If they're saying it's just a placeholder, then how are they making assertions of prejudice if it's just something there? So it sounds like the state is saying that those are just words that they included because that was the standard that they needed to meet, rather than actually determining that they had suffered prejudice because it was merely a placeholder. So we would ask the court, again, to grant the defense motion. Thank you, Your Honor.
Thank you for your presentations, counsel. The court makes the following ruling, which will be followed up by a written order. The court denies the expedited motion for order excluding witnesses. I did not think that the defense has demonstrated the prejudice that is required under State v. Harper. The defense was on notice that the state may call defendants' witnesses through their May 6th witness list addendum. And given this notice, the court does not find that defendant was prejudiced by the later filed June 2nd, 2024 witness list addendum. With respect to the judicial estoppel argument, that also is denied as part of this order, because the doctrine is to prevent parties from playing fast and loose with the court by successfully arguing one position and then later adopting a position inconsistent with the first. And there, I don't think you've met the prongs of, first of all, they didn't successfully argue before the court, and also I don't think that there's the prejudice as contemplated by Hutchins. So you'll get these orders next week.